This is the second of 3 videos describing the changes that GDPR brings to the way we look after data as opposed to the existing Data Protection Act. When you're considering the data and how you use it and what you do with it, risk is going to feature through lots of the things you do. And certainly when you consider that there's a high risk to the data subject, there's a need now to perform a Data Protection Impact Assessment, a DPIA, considering the impact on the data subject if that data was to be breached, lost, set into the wild by accident. The fact that you need to do the assessment is there so that you end up reflecting on all the things that matter about it and how you can minimise that impact in the event that something does go wrong. But again, we'll probably come back to that in some subsequent video. Risk also features in other areas though. Certainly if you're trying to get the data dealt with, processed elsewhere in the world, so if you're trying to export it effectively, you very much need to be considering the risks that you're undertaking there. Within the EU or the other adequate areas, and that does include the UK, everybody's deemed to be covered by the same legislation. So within reason, you're entitled to assume that when the data goes into their hand, they're going to carry some responsibility for how they look after it. If by chance you were to outsource it to another part of the world, particularly some of the prime outsourcing areas like the Indian subcontinent, African subcontinent, the Philippines, that sort of thing, their data protection regime may be nowhere near as safe. And whilst it's not absolutely forbidden to use a provider in those areas, the onus that you are carrying for doing so is greatly increased. Effectively, it means you have to enforce your own data protection regime on everybody who goes close to that data at your own expense and at your own liability if it goes wrong. For most small to medium companies, it frankly isn't worth it. It makes more sense to have your data protection issues looked after by the legislation and to keep it in the EU or in one of the other acceptable territories. Interestingly, as I talk to you now, a year ahead of go live, the United States of America is not one of those adequate areas, although there's a likelihood that it will be resolved. At the moment, there's still some fairly detailed conversation going on as to quite how that will happen. Specifically, there's a whole host of different legal bases upon which you can choose to process data. So, for instance, there is one of them which is consent. We will look at the different lawful reasons for processing in due course, but one of them is consent, and that's been around for a little while, but the definition of consent has been really, really beefed up. It's much more robust now. It is very explicit that for the consent to be considered valid, the person who gives you consent must have done so freely. They must have been informed and they must have been knowing what it was all about and what they were consenting to. They must have had no downside to refusing, or else perhaps they were being pressured to give consent to all intents and purposes. Effectively, they had to have a relationship with you which was one where they were perfectly entitled to say no thank you, and they chose not to do so, having been properly informed about everything. We'll go through it in more detail as a separate subject because it's now quite a big deal, but if you are relying on consent currently for the old data protection version of consent, you definitely need to open the book again on that one and make sure that what you're doing is appropriate for the new legislation.